for Mr. Sanchez. I believe he's going to sub in.
We have that already? Had we received it?
Judge, I think we did like 2 days on the 27th.
Okay. All right, good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket for February 1st, 2021. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Pantoja, would you call our next case, please?
Yes, Judge. It's cause number 20-0D0-2041, State of Texas versus Filimon Mitchell Sanchez. Announcement of council, please.
Roa King for the state of Texas.
And Daniel Avalar, sorry, Judge, Daniel Avalar for Filemon Sanchez.
Okay, so just to be clear, I guess we had a motion to sub. Oh, there it is. Okay, on January 26th.
Yes, on the 26th.
All right. All right, so we are scheduled. Mr. Sanchez is appearing from the downtown jail. Mr. Avalar, you may proceed. We're set for, I guess we're just set for a status.
It's just a status, Your Honor. Yes, ma'am. We did file the motion to reduce, Your Honor. But we are set for a status today. We kind of chatted about it, Ms. King and I, a little bit before our hearing. And I think we both agree that we should probably have this hearing maybe next week, right, when it's convenient for the court.
Well, it's convenient right now. What do you have?
So, Judge, I was just going to proceed on, the usual, his usual stuff. I thought he had one pen trip. It turns out that I think he has two, so he's habitualized. So I can imagine that the court might be inclined to say that he is a flight risk. But Judge, he's from El Paso. He has a family.
Well, hold on. So the bond hearing isn't set. I mean, if Ms. King wants to go ahead and we don't actually have it set.
Right.
It's up to you if you want to proceed on that or not. I don't know to what extent you, yeah, I mean, time is a concern. So if you're going to request the bond, I don't have a problem going forward if Ms. King is good to go, but it wasn't scheduled for today.
It wasn't scheduled, Judge, and I would rather be more prepared to make a better argument for Mr. Sanchez than that. Plus, I think we can discuss terms and conditions, Ms. King and I, should she be inclined to kind of not necessarily agree, but other terms and conditions that she might want.
So
And
since
Judge, I have pulled the rec that we have, and because there has been a lot of back and forth on this. So I think Mr. Avalar should review this case a little more in depth because of the history.
Right. What I can tell you, Mr. Avalar, is yes, we've had a lot of difficulty on this case. I know we were scheduled for a motion to suppress latter of 2021, either November or December, and that even having that happen was an issue. What was the previous rec, Ms. King? I don't recall.
Your Honor, it was going to be 60 DC for count 1 and a lesser included for count 2.
Okay.
Say it again.
So let's see, count 1, I apologize. Count 1 is lesser included, and then count 2 was enhanced to a 3rd degree, and that would be 60 DC, $6,000 fine, probate $5,500, and then your fine and court costs. But I have pulled that rec off. So, and
when you say, yes, ma'am.
Go
And
ahead.
when you say lesser included, it's because one of the counts is a 1st degree.
Let's see.
Count 1 is a 1st degree,
Okay.
It's the Mendel is the 1st degree.
Okay. And that rec, as of today, is pulled.
The rec is off the table, and I will update portal with an updated rec.
So because we're looking at such a short timetable, there's a couple of things outstanding. So Ms. King, I know you may need to do some reevaluation if that's That's what you're doing in terms of a rec. If there's going to be a new one though, please do that fairly quickly because Mr. Avalar is stepping in to a lot of work, I guess, because we do have a trial setting for March 18th. We need to go ahead. Oh, we have on both dates, the 17th and the 18th. I have panels, Mr. Avalar, for those days. And so I know with Mr. Decote, we were already looking at, not excluding the motion to suppress and whatnot. We were looking at that at being an actual trial date. It's not a, we're just here and trying to follow along and see where we end up. That is an actual trial date. So anticipate that's real. So if you want to ask for a hearing on the bond, please do that ASAP, number one. Number two, we need to have, or if you are going to re-urge the motion to suppress that was filed, we need to have that hearing like in the next 2 weeks. So I'm gonna bring you back next week on a status.
That's understood, Your Honor. Yes, ma'am.
Okay, so I know it's kind of a quick turnaround for you, Mr. Avalar, but I think everything was in place to get this moving, either via motion to suppress, plea, or whatnot, but for your client's cooperation. Okay, so we're coming back next week on another status. Danny, we need to move this very quickly because if you want to go on that motion to suppress, we gotta schedule you in, and I know I'm already filling in some empty days, so there might not be a lot of time.
Ms. Kim did give me a general breakdown of a very general breakdown of what was going on. We didn't talk about what the suppression issue was, Judge. So I'll look into that, Your Honor.
Okay. All right. Then we'll come back next week. Thank you, Mr. Avalar.
Yes, ma'am. Thank you.
All right. Is that it from the downtown jail?
Yes, that's it.
Yes.
Okay.
Thank you. Thanks.
Thank you, downtown.
May I be excused, Your Honor?
Yes, sir. Is that all you have?
I think so, Judge.
Yes, it is, Judge.
Okay.
That's all you
all
have.
right.
Thank you, Danny.
Thank you. Assalamu alaikum.
Annex, if we can get Arlis Ramirez, please. Ms. Ramirez?
Sí,
Okay. Speak
Spanish?
English?
un poco.
Who says this one?
Ramirez, Judge, on page 8, I wasn't aware that she needed an interpreter, if she does.
It's a bond hearing. Mr. Roberts,
Yes, Your Honor.
your client doesn't speak English.
Well, I conversed with her in English. So I was unaware that she only spoke Spanish.
Are you okay to proceed without the interpreter? Can you ask her? Señora Ramirez, ¿está bien si, I'm going to ask her if we can proceed without the interpreter if she wants. Si todo lo que sucede aquí en esta cita tiene que ser en inglés. Si quiere, podemos pedir que venga alguien que le interprete lo que estamos haciendo. ¿O está bien si su abogado se lo comunica después de su audiencia?
Pues, si quiere, así continuamos.
No le entendí. ¿Qué dijo?
Si quiere, así continuamos.
Confirmamos que.
De continuar así el court sin que alguien me diga en español.
¿Si quiere un intérprete o no quiere?
No.
No, she'll proceed without an interpreter.
Yeah.
Okay. Yeah. Okay. So what I'm understanding, Mr. Roberts, is that she's willing to proceed without an interpreter.
I understand, but do we have the right defendant here? What is,
Ms. Ramirez? Arlette, ¿usted sí es Arlette Ramirez?
Sí.
Do you not
okay.
recognize her, Mr. Roberts?
I've never seen her before. You know, in this, we have not visited. And like that, I just was able to converse with her in English at an earlier proceeding. Not a proceeding, but on phone calls from the jail.
Understood. Understood. Okay. All right. Are you all wanting to proceed on the bond hearing, Mr. Roberts?
We do.
Okay. Chewy, did you already call it?
Not yet, Judge. I will. Calls number 2021-0D03227, State of Texas versus Arlith Ramirez. Announcement of council, please.
Proa King for the state of Texas.
Charles Roberts for the defendant.
And Ms. Ramirez has indicated off the record that she is in agreement to proceed with the hearing today, Mr. Roberts, without an interpreter. You are also in agreement with that?
Yes, we would waive an interpreter so we could have the bond hearing. Yes.
All right, you may proceed on your bond hearing.
Your Honor, she is a longtime El Paso resident. What happens was she was released on a PR bond and she picked up another drug charge. Since then, she's been working on her rehabilitation in the jail, and she's asking for a split bond. I don't have a copy of it in front of me, but the kind of bond that she could make is listed in my motion.
Okay. Anything else?
She has immense amount of family in El Paso. She does not pose a danger to the community nor a flight risk.
Okay. Ms. King?
Your Honor, the state respectfully opposed for the reduction of the bond. There is actually an outstanding charge, conspiracy to enter, transport, or harbor aliens from New Mexico. The offense date is actually April 20, 2021. That is still pending. We also have the pending charges for possession of marijuana. We also have another P file for PG1, possession PG1. And it's actually, I have followed up with screening. It is still pending.
Is this a federal charge?
Let's see. Those are the other two charges from the same.
Yes, no, but the one you mentioned first, the one from New Mexico.
I believe so, yes. That's what I see on the rap sheet.
I was unaware of that.
That is still pending.
What is the case that was declined, Ms. King?
I believe it was.
Your Honor, are you asking about the decline on JMAG 21-12335?
You know what, I'm not looking at. Yeah, I don't have it in front of me, but I did see there was one decline, Marissa. Which one?
Okay, there was a decline filed for on 12/16/2021 for JMAG 21-12335, and the arrest warrant on that lists possession of controlled substance PG2 between 1 and 4 grams.
Does it show a date of offense? Is that the October 14th?
Yes, ma'am. Date of offense, October 14th, 2021.
Okay, and out of the same incident, we have manufactured delivery 4-200. Is that right?
I do have another arrest warrant for that one, yes.
Your Honor, that one I believe is separate.
The reason I ask, I'm looking at the, because these PR revos came out of JMAG, and it does list what I think is the decline case as the basis for the of pulling the PR bond. And that one has since been declined, but then it also lists a manufactured delivery between 1 and 4.
So the date of offense for that one is the October 14, 2021.
So
The
they
other
kept,
one,
so they kept one and they declined the other one, the PG.
I believe so, yes.
Arrest declined, reason 19 and 20. Session on the 16th.
The P files, actually, the date of offense is June 7, 2021. So we have two different offense dates. The one that we're on today occurred on October, and the P files occurred on June.
So those are, yeah, those are the ones we have, right? Like the June 7th offense is this case, right? 2021, 3227.
No, Your Honor, the one that we have is the one for October 14, 2021. We're waiting for the June offenses.
Okay, I see. That's weird. So we have the ones that occurred later and we don't have the ones that occurred in June. That's what's
Correct.
happening. All righty.
And then New Mexico is the April 2021. 2021.
Okay, and Mr. Roberts, let me see if I'm understanding. This seeks a split bond of 50,000, corporate surety 10,000 PR bond. Is that right?
Yes.
I thought her bond was less than that. Marissa, what's her bond? I thought I saw 59,000, something like that.
Yes, Your Honor, the total amount is 59,000 on the indicted case. The current bond amount is the current bond amount is 35,000, and then on an unlawful carrying, that's a misdemeanor. I think it's listed as that's a 4,000 cash or surety bond. There's a possession of marijuana that's $100, and a possession of CSPG1 is 20,000. So the total is 59,000.
Okay, but as to this case, I guess I'm a little confused, Mr. Roberts. Please correct me. You're asking for a bond that's higher than what?
By $100.
I'm sorry?
By $100, yes. In a sense, we were asking for 50,000 PR and a 10,000 corporate surety.
Okay, but Marissa, 3227, the cause number ending 3227 has a $35,000 bond, right?
That's correct, Your Honor.
Okay. And Ms. King, you're opposed to any bond reduction, correct?
Yes, Your Honor.
Okay, so Mr. Roberts, I'm going to go ahead and deny the request to reduce bond. Ms. King, if you have any way to try and expedite those June cases, I'm getting myself confused now. The October cases, the June case, whichever cases we're missing, if you will please run it up the chain and see where they are.
I will, Your Honor.
All right,
Yes.
thank you very much. Thank you, Mr. Roberts.
Yes, Your Honor. Is there a federal hold on her?
I thought I saw one. Marissa, did you see that? Let me go back.
I don't see an active hold. There were holds, but I don't see an active one.
Okay.
Okay, well, I will try to investigate the New Mexico federal case.
All righty. Thank you very much, Mr. Roberts. Be safe. Take care. Thank you, Ms. Ramirez. Who's next?
Annex, Mario Becerra, Judge. Annex, if we can get Mario Becerra. Thank you.
Judge, and if you'll hold off, because that one was set for a plea, Judge, but I'm asking for a continuance on that one.
Mr. Vasquez, I have you down for a bond hearing. I don't even have you down for a plea.
I have Manuel Becerra.
Mario
Is he set for a
Becerra.
bond hearing? Oh, okay. I'm sorry, Judge. It's just that I could receive plea papers today, so I figured at the same time. I was
Is this Mario Becerra?
yes.
Okay, are you waiving your bond hearing?
No, Judge. Go ahead and go
Okay.
forward with it.
All right, go ahead, Chui.
Yes, sir.
Sorry about that.
Okay, it's okay.
Cause number 2019-002380, State of Texas versus Mario Becerra. Announcement to council, please.
Laura King for the state of Texas.
And Joseph Vasquez representing Mr. Becerra.
And do you recognize your client, Mr. Vasquez, appearing from the jail annex?
I do, Judge.
Okay, we're set for a bond hearing. You may proceed.
Let me get his file.
Sure.
I'm sorry, Judge. Let me get it. I have it put away. Like I said, I thought it was a plea and I was resetting the plea, but let me grab his file. Hold on. Judge, my client has been in jail since August or September. He was out on out on bond on his original arrest when he was picked up on a bond violation and jailed again. He lives in El Paso. He was married. His wife passed away in November while he was in jail. He does have a daughter who resides here in El Paso. He lives alone on the west side off of Donovan and Mesa, Judge. I don't have the address in front of me. I apologize. He is a lifelong resident of El Paso. Judge, this would be his 5th DWI, I believe. And he was convicted of a felony DWI where the probation was revoked and he was sentenced to 2 years TDC. I did file a motion to suppress, Judge, and I did go out to the area where the sheriff deputies indicated he committed a traffic infraction. Basically, they alleged that when he made a right turn off of Donovan on the street to go up to his home, that he cut the corner and drove on the dirt. I went out to the scene, and in the corner, there's clearly a speed limit sign or some kind of traffic sign right there on the corner. In addition, there's a curb. And it's my position that if he had made the turn the way the officers allege in their reports and in their statements to my client when they're investigating him and ultimately arresting him, they indicate the reason for the stop was the way he made the turn. I have spoken to Mr. Flores. He asked me to get with the city and make a freedom of information request to see if those signs had been placed since after his arrest. And I have made that open records request and I'm waiting for those results. But I'm asking the court so that he can mourn the loss of his wife, and his daughter is willing to help him get services and make arrangements for him while he's out on bond to give him a PR bond and allow him to be out while we continue this investigation and wait for those records.
Ms. King.
Your Honor, the state respectfully opposes to reducing the bond. So technically we are on our 8th DWI. The first one started in 1987, then we have 1991. We have an assault family violence in 1992. We have another DWI in 2000, another one in 2001, another one in 2006. We have another AFV with a prior conviction as a felony in 2010. We have 2019 DWI, and we have DWI out of New Mexico in 1979. Here we are again. His breath was actually 0.274 on this DWI, Your Honor. So we have a mix of alcohol problem with violence issues.
So I also see a JP7 warrant for driving without a license. So not only do we have an alcohol problem, we clearly have at least 4 decades of driving while intoxicated. I don't know how you haven't killed somebody, Mr. Becerra, honestly. Your request for a bond reduction is emphatically denied. Mr. Becerra, you don't know how to follow rules. I'm very sorry because life circumstances doesn't sound very good. You've gone through the passing of your spouse, but you're not getting out unless you bond out with the bond that you have. So we're good to go. Mr. Vasquez, if you need to have that motion set, please get it set as soon as you're ready to go forward.
Yes, Judge, as soon as I get that open record request, I'll get it set.
All right, thank you very much.
Thank you,
Who's
Judge.
next? Who's next? Judy?
Okay, Judge, Anchondo. Annex, if we can get Salvador Anchondo, please.
And the attorney information has been updated on that other case.
Okay, thank you.
And Mr. Anchondo, Mr. Vasquez?
Sorry, Judge, would you ask me?
Hey, is that your client, Mr.
Yes,
Anchondo?
it is. It is.
Okay, let's go, Chewy.
Yes, Judge. It's cause number 2021-0D0-2001. Call 2021-0D0-3123. State of Texas versus Salvador Manuel Anchondo. Announcement of council, please.
Robert King for the state of Texas.
And Joseph Vasquez representing Mr. Anchondo. Judge, my client has two indictments pending. The 2021 0D0-3123 has two counts, one being burglary of building and the second count being harassment of a public servant. And that has a bond of $10,000. And then he has the 2021 0D0-2001, which is an aggravated assault. And that also has a $10,000 bond. So in aggregate, he has bonds totaling $20,000. My client is a U.S. citizen, Judge. He was born here in El Paso, Texas. He attended Burgess High School and Parkland High School. He did not graduate. He lives at 1300 Pera, P-E-R-A, apartment number 31 here in El Paso, Texas. At the time of his arrest, he was working at Timo's Seafood and Mexican Restaurant, and he had been working there for 2 months. Judge, my client does have a history of mental health issues. I have spoken to the representatives of Tacoma, and they are willing to assess him and work with him. But in order for them to provide services, he would need to be out of jail. If his apartment isn't still available, they can assist him with housing. But again, they need him to be out so that they can work with him and provide him services. Judge, my client has been to the penitentiary, I believe in 2008 and 2009. He served 3 years on an injury to child or elderly. I don't know which, or maybe both. I'm not sure. I think it was one sentence, Judge, but it was two separate charges. And then in 2016, he was convicted for a harassment of a public servant where he was sentenced to 4 years. Judge, in regards to the aggravated assault, he is alleged to have gotten into an argument with an individual at a bus stop there on Alameda or in the area of Alameda and Piedras. And they allege that he pulled out a thermostat, like a meat thermostat, to ensure that the meat is cooked at the right temperature. And that's the deadly weapon. There was no injury in that case. I have a recommendation of 2 years TDC on the harassment and aggravated assault and a reduction of the burglary of building to a criminal trespass. I just got appointed to the 3123 case, Judge, and I'm investigating that, and I will discuss those recommendations with my client. But I'm asking the court to grant him a reduction so that we can hopefully get him some services through Tacoma and stabilize him mentally.
Understand. Do you know, Mr. Vasquez, is he receiving any services in the jail right now? Is he any mental health services?
Judge, I think he's been assessed, and I didn't ask him if he was receiving medication, but I do know that he was assessed because they do have they are aware of his conditions.
Can I speak? Is there any way that I could speak?
Well, you can only answer a specific question. I don't want you talking about your cases.
No, sir. I wanted to just to kind of elaborate on as far as the mental stuff as well. I did have a case with Emergency Health Network that I've had for years. I have the same caseworker that I've had, and I was attempting to get that while I was out, but when I got released in January of 2021, I was homeless up until June. And throughout that time, due to the COVID, there was restrictions to where I couldn't go to the office unless without an appointment. I couldn't get an appointment until I was reassessed by them. And as far as the two charges that I got,
Don't talk about the charges.
what I do want to say is that when the original charge, I was on PR bond, and it was assessed that I was to have medical help. And I had several attempts to call on to get these assistance, and they never helped me. And as a matter of the day that I was actually arrested, I called 911 on myself because I was having an episode. I let them know about that. But I know if I'm out there and I was to have my mental health, if that's all I need is my medication. And as far as your question, yes, since I've gotten here, I let them know, and I've gotten back on my medications. I've been taking my medications, everything. I'm back to being in the same state of mind. I like, you could check the records here. I get medicine in the morning and at night. That's all I wanted to say, but thank you.
Okay, Ms. King or Mr. Vasquez, do you have anything else?
No, Judge, that's all I have.
Ms. King?
Your Honor, the state respectfully oppose the bond reduction. So we have a very long criminal history. We're looking at 25 pages of rap sheets starting from 2000. It involves around criminal trespass, robbery. We have possession issues. We have resisting issues. As we have a lot of assault family, ag assault, harassment of public servant, violation of protective order, evading again, harassment of a public servant, and the facts about these two cases are we're having an individual who seems to just go to bars. In this instance was headquarters, and kind of just, scare the bartender and take bottles of, in this one allegedly took a bottle of liquor and left. And the other case was, we have an individual who's walking around with a thermostat that you can easily stop someone with, and just sneaking up and creeping up on individuals at bus stations. There was a 1622 order in this case, and it was assessed that he should receive some help.
So let me understand, in terms of the jailings, he had that first jailing, they give him the PR bond, intensive supervision. I was looking at that bond order where they hooked him up with Takumi. And I think that's what your client, if I understood it correctly, represented. He was unable or had difficulty contacting or getting started. And then we pick up a new arrest. Is that right? Do I have the timetable right?
Yes, Judge, I think so.
Okay. Go ahead, Ms. King. Anything else?
No, Your Honor, that's in a nutshell.
Did we have any, in terms of the criminal history? I'm sorry, I didn't hear. Do we have any prior pen trips?
Yes, Judge.
Yes.
He has two pen trips, one in 2009 and one in 2016.
All right. Anything else?
Actually, we have, I believe, 3. The first one was for harassment of public servant that was disposed in 2017. We have another one, disposition 2008, injury to a child or elderly. And then we have another injury child or to an elderly in 2008 as well.
Judge, in my investigation of those, he pled to them on separate dates, but was revoked on one and sentenced to the pen on both of them on the same date,
At the
is
same
my
time.
understanding. Yes, Your Honor.
Okay,
Different offenses, but one sentence on both.
gotcha. All right, so each of them are at 10,000. Go ahead and deny the request for a bond reduction. We have our next hearing on March 1st. Mr. Vasquez, if you need anything before then, let us know and we'll schedule your hearing.
Thank you, Your Honor.
Thank
May I be
you.
excused?
You may.
Thank you.
Thank you, Mr. Anchondo. Who's next, Chewy?
Okay, Judge, Michael Martinez. Annex, if we could get Michael Martinez, please.
Yes, sir.
Mr. Martinez, is that you?
Yes, ma'am. Yes, Your Honor.
Okay, perfect. And I can hear you just fine. Mr. Dakotes, you ready?
Yes, Judge.
All right, Chewy, call it.
Judge. It's cause number 2021-0D01222. State of Texas versus Michael Allen Martinez. Announcement of council, please.
Robert King for the state of Texas.
I don't know if I froze, but Carl Dakotes from Michael Allen Martinez. Ready, Judge.
And Mr. Martinez is appearing from the jail annex. Mr. Martinez, I am going to be asking you some questions, so I need to swear you in. Would you raise your right hand to the best that you can? You swear or affirm that any testimony you provide will be the truth and the whole truth.
Yes, Your Honor.
You can put your hand down. Sir, would you state your name for the record?
Michael Allen Martinez.
Mr. Martinez, we are scheduled for a plea today. So I'm going to be asking you questions mostly about documents you may have reviewed with your attorney, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Martinez, do you recall reviewing State's number 1 with your attorney and signing that document?
Yes, Your Honor.
Did you understand everything contained within the document?
Yes, Your Honor.
Mr. Dakotes, have you had more than 10 days to prepare a defense in this case?
Yes, Judge.
And did you explain the plea papers to your client?
Yes, Judge.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
I believe so.
Mr. Martinez, are you satisfied with your attorney's representation of you?
Yes, Your Honor.
And Mr. Dakotes, do you have any reason to believe your client is not presently competent to enter a plea?
No, Judge.
Mr. Martinez, have you ever been found incompetent by any court?
No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, Your Honor.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea. Sir, are you a U.S. citizen?
Yes, Your Honor.
Where were you born?
In Alamogordo, New Mexico.
Okay, so the charge against you, I believe, was originally indicted as a first-degree felony, manufacturing delivery, but I understand through negotiations, you are pleading to the lesser included offense of possession of a controlled substance in penalty group 1 in an amount between 4 and 200 grams. That is a second-degree felony. To that lesser included charge, what is your plea? Guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Yes, Your Honor.
I will find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of the offense charged, manufactured delivery in an amount between, between 4 grams and 200 grams in penalty group 1 count beyond a reasonable doubt. Judge, the defendant will be pleading to a lesser included of possession of controlled substance between group 1. Between 1 gram and 4 grams and 200 grams. And for 5 years in penalty group 1 for 5 years of deferred adult probation, and to dismiss the misdemeanor charge, cause number 2021-0C03169. At this time, the state moves to admit Exhibit 1 as the state's plea paperwork, Exhibit 2 as Article 3914 disclosures, and Exhibit 3 as the indictment.
No objection, Judge.
And was that also your understanding of the plea agreement?
It's my understanding also. Yes, Judge.
And okay, so states exhibits 1, 2, and 3, I guess, are admitted. Mr. Martinez, was that your understanding of the plea agreement as well?
Yes, Your Honor.
Okay, I understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Martinez, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, Your Honor.
Okay, finally, the last document, the motion for deferred adjudication. Mr. Martinez, do you recall reviewing and signing the motion for deferred adjudication?
Yes, Your Honor.
Mr. Coates, have you explained to your client both the benefits and detriments of deferred adjudication?
Yes, Judge.
Mr. Martinez, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for this offense? Do you understand that?
Yes, Your Honor.
And are you asking the court to grant you deferred adjudication?
Yes, Your Honor.
Okay. I will find there is sufficient evidence here to substantiate a finding of guilt. However, I will not enter a finding of guilt at this time. Instead, I will defer further proceedings and place you on committee supervision pursuant to the plea agreement for a period of 5 years. There will be a $4,000 fine, $3,500 of which is probated, which means as long as you're in compliance with your probation, there's only that difference that you owe on the fine. If at some point you are not in compliance, they can come back and collect the entirety of the fine. 500 hours of community service, screen for TAP, court costs, urine breath analysis, curfew, drug offender education class. There's $180 of a lab fee that is owed, and then the dismissal to the misdemeanor court in cause number 2021-0C03169, I assume will be forthcoming. Is there anything further, Mr. Coates or Ms. King?
No, Your Honor.
No, Judge. Thanks.
Thank you very much. Good luck to you, Mr. Martinez.
Thank you, Your Honor.
Okay, who's next, Sri?
Hey, Barnaby Chavez, Judge. Annex, if we can get Barnaby Chavez, please. And this one will have a victim impact statement, Judge.
May I be excused, Your Honor?
Yes, sir. Thank you, Mr. DeCotes.
Okay, I think the honorable court got my substitution on C. Lemon Sanchez.
Yes, I had not, but I got it pretty much simultaneously with the hearing. So thank you for your assistance in that case.
You're welcome. Enjoy, Your Honor.
Send your voucher over whenever you have it ready.
I will. Bye-bye.
Bye-bye. Gosh, he was happy. All right, what happened?
Good afternoon, Your Honor. I'm here on Barnaby Chavez's plea.
Sure, I was thinking, it looks like, yeah, I was wondering if he was the gentleman that was in a wheelchair or was seated. Mr. Chavez, is that you?
Yes, it's Your Honor.
Perfect, I can hear you just fine. All right, we're set for a plea delay. Let's get started. Chewy, if you'll call it, please.
Yes, Judge. It's cause number 2020-020-6487. Cause number 2021-020-0712. Cause number 2021-020-2709. State of Texas versus Barnaby Chavez. Announcement of counsel, please.
Roa King for the state of Texas.
Manuel Parra for Mr. Chavez.
Mr. Chavez is appearing from the jail annex. Mr. Chavez, we're scheduled for pleas in all three of these cases. I'm going to be asking you some questions, so I need to swear you in. If you would please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you very much. Can you put your hand down? Just make sure if you please keep your voice volume loud enough. And also, Mr. Chavez, if at some point you can't hear us, let me know and we will go back and repeat anything you haven't heard, okay?
Okay.
All right. As I mentioned, well, actually, would you state your name for the record, please?
Barnaby Chavez. I'm sorry.
Mr. Chavez, as I mentioned, we're set for pleas. I will be asking you questions. The first of which will be about documents. States Exhibit number 1 are the plea papers in these cases. So there's a States Exhibit 1 for each case. Within that document, you were guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Chavez, do you recall reviewing States Exhibit number 1 for each of these cases with your attorney and signing those documents?
Yes, Your Honor.
Did you understand everything contained within the documents?
Yes, Your Honor.
Okay, Mr. Barra, have you had more than 10 days to prepare defenses in these cases?
We have, Your Honor, yes.
And did you explain the plea papers to your client?
Yes, I did, Judge.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering pleas today?
Thoroughly, Your Honor.
Mr. Chavez, are you satisfied with your attorney's representation of you?
Yes, Your Honor.
And Mr. Parra, do you have any reason to believe that your client is not presently competent to enter pleas?
None whatsoever, Judge.
Okay. Mr. Chavez, have you ever been found incompetent by any court?
No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, Your Honor.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Mr. Chavez, are you a U.S. citizen?
Yes, Your Honor.
Where were you born?
Los Angeles, California.
Okay. So in cause number ending 0712, the charge is abandon or endangering a child, criminal negligence. To that charge, sir, what is your plea, guilty or not guilty?
Guilty, Your Honor.
And in cause number 6487, the charge is unauthorized use of a vehicle. To that charge, what is your plea, guilty or not guilty?
Guilty, Your Honor.
And in cause number ending 2709, the charge is abandon or endangering a child, intentionally, knowingly, recklessly, criminal negligence. To that charge, what is your plea, guilty or not guilty?
Guilty, Your Honor.
Are you making each of your pleas freely and voluntarily?
Yes, Your Honor.
I will find you are making all of your pleas freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element the offenses charged: abandon, endangered child, criminal negligence, and cause number 2021 0D00712, unauthorized use of vehicle, and cause number 2020 0D06487, and abandoned, endangered child, intentionally, knowingly, recklessly, criminal negligence, and cause number 2021 0D02709, beyond a reasonable doubt. Judge, the defendant is pleading to 2 years probated for 5 years of straight adult probation and other terms and conditions listed in the state's plea paperwork. Additionally, there is a restitution amount of $1,378.95 to complaining witness in the name of Hayro Rosales and cause number 2020 0D06487. At this time, the state moves to admit Exhibit 1 as the state's plea paperwork and all cause numbers, Exhibit 2, Article 3914 disclosures, and Exhibit 3 as the indictment in the remaining cause numbers.
No objection, Your Honor.
Without objection, states Exhibits 1, 2, and 3 are admitted. Mr. Parra, was that your understanding of the plea agreement, including the
Yes, Your Honor.
restitution? Okay. Mr. Chavez, was that your understanding as well?
Yes, Your Honor.
Okay. Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document, again, one for each case that I'm going to ask you about, is the trial court certification of your right to appeal. It is a document that explains your appeal rights. Because these are plea, bargained, or negotiated cases, you do not have an automatic right of appeal. Mr. Chavez, do you recall reviewing and signing the trial court certification for each of your cases?
Yes, Your Honor.
They were signed by your attorney and signed by me as well. So on your plea of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. In cause number 2021 0D00712, I will find you guilty of the offense of abandoning or endangering a child by criminal negligence. In cause number 2020 0D06487, find you guilty of the offense of unauthorized use of a vehicle. And in cause number 2021 0D02709, find you guilty of abandoning or endangering a child. Each of these cases, I will sentence you according to the plea agreement to 2 years confinement in the Texas Department of Criminal Justice State Jail facility that will be suspended for a period of 5 years of community supervision. There will be a $4,000 fine, $3,500 of which is probated, 400 hours of community service. You will be screened for TAP. You will be reporting weekly and will be subject to random or unannounced urine and breath analysis, curfew, court costs, drug counseling, parenting classes. As for cause number 6487, there is also restitution in the amount of $1,378.95 payable to Jairo Rosales. These will all run concurrent with one another. Is there anything further other than the victim impact statement, Ms. King or
No,
Mr.
Your
Fox?
Honor.
Mr.
Not at this
Fox?
moment, Your Honor. No.
Okay, so we are now going to be off the record for our victim impact statement. Ms. Rosales?
Hello, good afternoon, Your Honor.
Good afternoon.
Do I just speak? Do I just say the whole thing? Well, I am a believer in the court system. I'm a believer in the point of prison, which is restitution at the end of the day. I hope that you, sir, getting another opportunity, understand, it's not okay what you did. You really impacted me in a time where I was having a lot of financial difficulties as it is. My husband had just lost his job a couple of weeks before. We were borderline about to lose our house, and I was working doing delivery services like DoorDash, Instacart, all of those things. And having lost my vehicle, that put me at no income whatsoever. My husband tried to also start doing delivery services in his vehicle, but he had an accident. So we were down to 0 vehicles, 0 methods of transportation, 0 ways of getting money. And we were literally borderline homeless because we couldn't go to work. We couldn't find jobs because of the pandemic. I couldn't even do my job, which is simply delivering food, because I didn't have a method of transportation. It took me well over a year to be able to get back on track, to be able to keep my house. Thank God I was able to do that. My husband and I had to fight extra hard to keep our house, to be able to find new jobs. And it was just a really difficult time for us. We really couldn't do anything because there's nothing you cannot do in modern day society without a car. I live in the suburbs, so, I cannot even go to El Paso to get anything. I cannot go to the grocery store to get my groceries. I don't have an income, so I cannot even pay my house just because of a missing car. It was also like, not just the financial part that is so much of a bother. It was also kind of like a broken sense of pride in my part, because this is actually the first vehicle that I purchased for myself. Fortunately, I come from a relatively good, doing well family, and my mom had bought my first 2 vehicles, and this is the first time that I had bought myself my vehicle, and I was finally free from everything, and I was finally doing things for myself. And I am emotionally attached to my vehicle. I know some people have something against people being emotionally attached to property, but it is something that I worked hard for. It's something that I was working crazy hard for. And it's just like a sense of pride that I finally did it for myself, that I was able to do something on my own without having to have my mom's assistance, without having to have any of my family's assistance. And yeah, it was just really hard to come by it. And then because I didn't have a job, and my husband didn't have a job because he couldn't find the job in what he does, I finally got my car back a month after it was stolen. And then I had to come up with $1,000 to pay my deductible, all while still paying for a car that I didn't even have. And yeah, I had to come up with those $1,000. It took me about 3 months to be able to come up with those $1,000. And thankfully, I was able to find a body shop that did a good job and gave me a bit of a discount so I could get everything done. But it was a huge expense. It was not only getting the vehicle fixed, but also getting a new registration, because while the vehicle was stolen, the registration expired. It was getting an oil change. It was getting new tires for the vehicle because the vehicle had been used for racing, according to Harassment PD. It was just a lot of expenses. Also, the tow yard, the vehicle had to stay there about 3 days. It was really hard to allocate the vehicle because Harassment PD said it was somewhere, APPD said it was somewhere else, and it was just a mess. So my vehicle ended up staying in the tow yard for about 3 to 4 days, and that ended up being almost $400 in expenses. And then when I finally got to the place where my vehicle was being stored, your girlfriend appeared and said that my car that I've been paying for, still while it was stolen, was her car. She told everyone it was her car, and she had taken every single document along with my laptop. Every single thing that was in there was missing. And she still had the guts to go tell the person at the tow yard that the vehicle was hers and that it was under her insurance. So it was not only the fact that it was already all this damage being caused, it's on top, like the cherry on top was still having to prove that my car was my car in the tow yard because your girlfriend decided to say it was her car. And fortunately, of course, the person in the tow yard, he was very helpful. And of course, he believed us. He knew everything that had happened. So thankfully, we were able to retrieve the car, but we had to be there an unnecessary amount of time being able to get the vehicle back. And then I had to meet with your girlfriend about an hour or so later so she can return all of my belongings to me. I met her at the Walmart on Horizon. She gave me a box with all of the documents that were in my car. So it was the registration, my husband's social security number, my social security number. Since we were applying for jobs, we had those handy. All of my birth certificate, my husband's birth certificate, his high school certificate, all of our documents, she returned to me in a little box at Walmart in Horizon. And it was, when we thought it was all finally over, she still continues to contact my husband. As of probably 2 or 3 weeks ago, she's been contacting my husband to drop the charges and do this. When I didn't place the charges, that was on the DA's office. I didn't have any saying in anything. That's not me. That I didn't do anything because I didn't care. I just wanted to get it over with. I wanted to have my car back. I wanted to get my life back on track. That's all I wanted. And she's still been contacting my husband. As of recently, my husband did finally block her number, but he has still been getting messages from her telling him like, oh, well, we left this thing in the car. Is this thing in the car? Well, those things shouldn't have been in my car to begin with. Anything that you left in the car, she took. She went to the tow yard. She took her things, everything that was there. But yes, she still has the guts to come and message me like, oh, is this there? Is this there? Nothing is there. My car has been cleaned. I don't want to think about it. I don't want to have anything to do with that because it was a very hard time for me. Not just because it was property, but because I couldn't do anything to solve it. I couldn't just go get a new car because I didn't have a job. I couldn't, just drop everything and be like, oh, like, that's fine. Like, I'll just get a different job because I didn't have a method of transportation either. So I couldn't even get to a job. But yeah, that's pretty much it. I am not upset with you. What happened, happened. What is more upsetting is just the kind of rubbing it in my face after 1.5 years now. Like your girlfriend still trying to contact us and all of that. So that's what's really annoying because honestly, I left it behind. What you did, you did. I hope that this is a learning experience for you and you learn to take better decisions in the future, which I really hope you do. And yeah, I mean, I'm not upset at you anymore. If I was at a point, I mean, that was in the past, but I am not a person that holds a grudge, especially for this long of time that has already passed. But yeah, what is really upsetting is still having your girlfriend try to contact us about this and about that. Aside from that, no, I mean, I'm not upset anymore. I think at the moment that I saw my car back, and even though it was crashed and everything, that kind of just put me, it just gave me a certain closure. Like, you know what, my car's here. I'm gonna work extra hard to try to fix my car and get my job back, doing the delivery services and just getting everything back on track. And although it took a while, we're mostly back on track. We didn't lose our house. We didn't lose anything And yeah, like I really am not upset anymore. That's pretty much everything I have to say.
Thank you, Ms. Rosales.
Yeah, thank you, Your Honor.
Thank you, Mr. Parra. I will say this, I don't know if Erica, if you're still there, let's just get back on the record on these cases. I do not recall that I don't have in my notes anything regarding any complainants, but it will be part of the conditions on probation not to have any contact with the complainants in any of these cases. Ms. King, I will leave it up to you. I was quickly trying to check if there were co-defendants. I only saw co-defendants on the abandoning case or at least on one. I did not see anything referenced to UUMB, but I'm going to be very direct with you, Mr. Chavez. We can't be harassing our complainants, whether it be you or someone acting either at your direction or someone you know of. That's not supposed to be happening, okay? So I'm going to keep a close eye on this in terms of those interactions, Mr. Parra. If you need to consult with him later on down the road. I understand sometimes people do things on their own. I'm not saying, if it's girlfriend and this is happening, I don't know, but I'm sure I'm not going to be putting up with any kind of, behavior that might be perceived as harassing or threatening to any complaints. So we're going to add that to the conditions of probation. And we'll go from there. Ms. King, I'll go ahead and leave that in your hands. Thank you very much. Good luck to you, Mr. Chavez. All right. Thank you, Ms. Rosales. Thank you, Mr. Parra.
Thank you, Your Honor.
Who was that?
Your Honor, just
Yes.
for clarification for purposes, I thought I heard you mention weekly reporting, but the reporting is for testing.
Okay, I just saw weekly and yeah, so maybe that was referenced the testing.
The testing. Okay, Judge. Thank you.
Is that what that meant, Ms. King?
Yes.
It was weekly? Okay.
Yes.
All righty, that's fine.